This report is in regard to the Bryan Kohberger case and the potential psychological effects of media coverage of the case on prospective jurors. Given my expertise in social psychology and the peer-reviewed research relevant to this issue, I believe that vacating the non-dissemination order would increase the potential for bias among prospective jurors, both initially and throughout the trial. My conclusion is based on my review of research illustrating that anti-defendant pretrial publicity increases the probability of guilty verdicts, and that this bias persists despite the receipt of trial arguments/evidence, admonitions to disregard the publicity information, and jury deliberation. I discuss this research in my report, along with research explaining why commentary by individuals with status/expertise, for example, police, attorneys, and judges, in media coverage create more potential for biased jurors. My background and qualifications: I have a doctoral degree in social and personality psychology from Michigan State University in 2002. My focus is social psychology, which is the scientific study of how social factors influence people's judgments, perceptions, attitudes, decisions, and behaviors. Currently, I am a tenured full professor and have taught courses in social psychology, social influence, self-perception biases, prejudice and stereotyping, research methods, statistics, and general psychology. Most of these courses cover scientific research that illustrates people's perceptual biases and the factors that may influence such biases. I have also conducted workshops on bias. Much of my research has focused on biased cognition as well. I have a number of peer-reviewed research publications and have given many formal peer-reviewed research presentations at local, regional, and national conventions in the field. Although my research interests within social psychology are varied, my main focus has been on social cognition, with a particular emphasis on bias, especially biases in self-perceptions, perceptions of groups, for example, stereotyping, and impressions of specific individuals, for example, relationship partners, strangers, friends, or acquaintances. My knowledge of distorted perceptions of self and others allows me to understand many of the factors that could bias individuals who make judgments of others, as in criminal cases. As a social psychologist, I can identify a number of ways in which media exposure regarding the Bryan Kohberger case or the parties involved would likely bias the opinions held by the public, and thus prospective jurors, in ways that cannot be mitigated easily or at all. I describe them in this report. In doing so, I provide only explanations that are founded in peer-reviewed scientific research and provide endnotes to specify the references that were used. The field of psychology sets high standards for methodological procedures and statistical analyses. As such, the peer review process is quite rigorous, resulting in primarily high-quality scientific research. Moreover, psychologists use strict cutoffs for statistical significance, so the probability of not detecting a true effect in the literature is generally much higher than the probability of a false finding existing in the literature. Several decades of research have established that anti-defendant pretrial publicity can negatively influence how potential jurors perceive a defendant's criminality and guilt. A 2011 chapter in the Handbook of Trial Consulting provides a review of this research. A meta-analysis conducted in 1999, which statistically combined the effects of 44 such studies and a total of 5,755 participants, confirmed that guilt judgments of a defendant were statistically significantly more likely to occur by people who had been exposed to such pretrial publicity. Meta-analyses particularly relevant because they are designed to determine the overall effect of a composite of all or most studies on a specific topic in order to make a general conclusion from the established literature. A similar 2022 meta-analysis published in Law and Human Behavior combined 45 studies, a combination of published and unpublished studies, 8 of which were also included in the 1999 meta-analysis, and yielded the same result. The overall finding was a significant effect of pretrial publicity on guilt judgments, both across the entire set of studies and for each of the 2 batches of studies published and unpublished separately. Most of the studies, including in the 2022 meta-analysis, had cases involving a violent crime, and the pretrial publicity effect existed for both student participants and community participants recruited to better resemble actual jurors. The studies included in the 2022 meta-analysis all involved experimentally manipulating exposure to pretrial publicity. In other words, participants were assigned, typically using random assignment, to be exposed to specific pretrial publicity or not, and then asked to review trial materials via summaries, transcripts, videotaped mock trials, or recordings of real trials. Although they cannot be used on real jurors, the big advantage of experimental manipulations is that researchers can make strong conclusions about cause and effect, given that participants are treated the exact same way and provided the exact same materials and instructions, other than what was manipulated, which was the pre-trial publicity information. Thus, different guilt judgments between groups can be attributed to the pre-trial publicity information. The 2022 meta-analysis found that anti-defendant pretrial publicity led to a significant increase in guilt judgments by individuals and guilty verdicts by groups like mock juries. Regarding individual judgments, most of the thousands of mock jurors exposed to negative pretrial publicity voted guilty, 55.4%, whereas fewer than half of the thousands who were not exposed to such publicity voted guilty, which was 45.1%. The anti-defendant pretrial publicity effect was over twice as strong when examining group verdicts. Among the 292 mock juries included in the analysis, about half, 49.7%, of those exposed to anti-defendant pretrial publicity voted guilty, whereas only a quarter, 25.2%, of those not exposed voted guilty. The 2022 meta-analysis also found that pro-defendant pretrial publicity significantly biases participants towards not guilty verdicts. Thus, bias can occur in either direction when prospective jurors are exposed to the media reports regarding a criminal case. Oftentimes, however, there is much more anti-defendant than pro-defendant media coverage, resulting in an overall prosecutorial slant. For example, in a study examining pretrial publicity for 20 capital cases, 75% of the media articles included some type of anti-defendant information. Arguably, even if the media presented equal amounts of pro-prosecution and pro-defense information, an anti-defendant bias might still emerge given that people have been shown to exhibit a negativity bias, paying more attention to negative information about people than positive information. Based on their findings, the authors of the 2022 meta-analysis concluded that judges, attorneys, and policymakers should consider this pretrial publicity effect and the circumstances surrounding pretrial publicity when evaluating how to best protect criminal defendants' right to a fair trial and when creating procedural safeguards. Although there are numerous potential reasons for why jurors might have a greater likelihood of reaching a guilty verdict after exposure to pretrial publicity, I focus on those that would be most relevant to non-dissemination orders given the issue at hand. Pretrial publicity of criminal cases may be impactful partly because a large portion of the coverage includes information sources who are authority figures, for example, police and attorneys, who likely exert a greater influence on the public. Large prevalence of stories including authority figures. Media reports in criminal cases often include commentary by people considered to have status or relevant expertise, such as criminal investigators, the chief of police, or attorneys involved in a case. For example, one study examining 20 capital cases found that over half of the news stories cited law enforcement and/or the prosecution, and that these sources were cited far more often than other sources and served as the primary basis for much of the pretrial publicity. A study examining 26 capital cases similarly found that news articles primarily cited these sources and did so in a way that depicted law enforcement commentary as objective facts rather than details which might be disputed in court. Greater persuasion by authority figures. Because people are generally raised to respect and believe authorities/experts, these type of sources would likely have a particularly strong influence on prospective jurors' pretrial opinions. Social psychologists have long discussed how people are more influenced by authority and status, sometimes even doing things that make no sense or that they believe are morally wrong because they have faith in the authority figure who is directing them. Research has shown that titles, uniforms, high-status occupations, and other indicators of authority status, such as affluence or even tall height, can influence people, even on matters irrelevant to the authority's specific expertise or status. Because of this, I believe that upon initial consumption of media stories, people would typically believe information more when presented by law enforcement or others with apparent status/authority/expertise. Authority status is a quick decision shortcut. Another reason that authority/status may exert greater influence is because it provides a quick decision shortcut for people to use when evaluating information. People tend to be cognitive misers and thus do not always choose to think deeply and carefully about matters. The elaboration likelihood model, a widely accepted and supported theory of persuasion, suggests that sometimes people are persuaded via deep information processing, but sometimes they are persuaded via peripheral route processing, which involves using quick decision shortcuts. One heuristic that can be used when coming across media stories is the notion that if someone is an expert or authority figure, then we can simply trust what they are saying is correct. We are more likely to rely on source cues like this when we are processing peripherally, which happens when we are distracted, tired, busy, unmotivated, etc. Although jurors should have more motivation, time, and cognitive resources during trial than people pursuing news stories, they may already have formed an opinion about the relevant case before any trial information is presented. Authority figures presenting more anti-defendant information. The information presented by the media may also have a stronger prosecutorial slant when it includes commentary by law enforcement and prosecution. One study evaluating news stories about crime and criminal defendants found the source of anti-defendant content in news stories was most often law enforcement officers and prosecution. Because jurors' judgments have been shown to be affected by the specific slant of the pretrial publicity, limiting the information presented by law enforcement and prosecution could reduce the amount of anti-defendant bias among future jurors. In other words, a non-dissemination order could reduce not only information from more influential sources, such as those with authority, expertise, status, but also the quantity of anti-defendant information presented in the media, which is the type that increases guilty verdicts among potential and mock jurors. Authority figures is biased selection and presentation of information. Some research finds that law enforcement officers may view evidence as more reliable if it is consistent with their preconceived notions about a suspect. If this influences which details law enforcement officers/agencies provide to the media or causes them to present details with more confidence than is warranted at the time, this could sway prospective jurors in the wrong direction. Law enforcement officers are subject to the same human biases that others have, but at the same time, are likely trusted more by the public because of their status. Prospective jurors are likely influenced by the valiance of evidence and information provided, the status of those providing it, and also the confidence with which it is presented, given research showing that people are more influenced by those who sound confident. Confirmation bias as a filter for new information. If media stories, including commentary from police, attorneys, etc., cause people to form an expectation of Mr. Kohberger's guilt, that belief will likely serve as an unconscious filter for new incoming information about the case. People tend to exhibit a confirmation bias, which involves the unconscious tendency to seek out and favor evidence that supports their initial opinions. Aside from directing their attention towards belief-consistent information, this bias also causes people to interpret ambiguous information as more supportive of their expectations than it actually is, and to dismiss or forget information that disconfirms their expectations. As such, news stories inferring that Mr. Kohberger is guilty or providing evidence or commentary to that effect would likely create an initial expectation of his guilt, resulting in confirmation biases as people become jurors in this case. Confirmation bias leads to the problem of pretrial/pre-decisional distortion, which has been discussed and tested as a reason for why pretrial publicity can bias potential jurors. Specifically, early judgments about the accused or the case stemming from exposure to the pretrial publicity causes distortion of new information learned about the case, for example, during trial. For example, in one 2004 study, some participants were given a short news article about a defendant describing that he had been arrested following a shooting incident. The only negative information provided about him aside from his arrest was that neighbors described him as a bully. This news story alone caused participants to be significantly more likely than those in the control group to view the defendant as having a criminal history, resulting in pre-decisional distortion. After later reading a trial transcript with various testimonies in which the defendant was charged with murder, the participants who had previously been exposed to the news article about the arrest were more likely to return a guilty verdict than those who instead had read an article on an unrelated subject. The authors specifically found that pretrial distortion from the article led participants to view new evidence regarding the case through their own filtered expectations, causing them to favor new testimony that aligned with their current leading theory regarding the accused instead of evaluating new evidence objectively. Certainly, jurors' viewpoints regarding a criminal case should change after becoming fully informed and presented with all the evidence regarding the case, but it is less likely that jurors would reach a conclusion diametrically opposed to their initial learnings, which may have arisen from exposure to media stories of the event. In other words, they would be less likely to conclude innocence if they had even a slight leaning towards assuming guilt because they are anchored by their initial judgments. It is noteworthy that pre-decisional distortion effects in both civil and criminal mock trials have been observed even when participants received formal instructions to suspend judgment until after all of the evidence was presented. Belief perseverance resulting in more pre-decisional distortion of information. If potential jurors have more than just a mild suspicion or expectation and have formed a strong opinion about Mr. Kohberger, their preconceptual biases can become even stronger. Belief perseverance is a phenomenon illustrating that people's belief often persists even when presented with information that completely discredits those beliefs. The more confident people are in their initial prejudgments, the more pre-decisional distortion will result when interpreting subsequent information. For this reason, media coverage that presents stronger suggestions of a defendant's guilt, for example, evidence, commentary by authority figures, would be expected to carry more weight. Because of confirmation bias and belief perseverance, it is not surprising that the effects of pretrial publicity can persist throughout the course of an entire trial and still influence guilty verdicts after all trial arguments and evidence are presented. One way in which this was demonstrated was by using a shadow jury paradigm, in which researchers exposed mock jurors recruited from jury-eligible community members to ongoing trial information as though they were active jurors during a 10-week time period. One sample of mock jurors was naturally exposed to pretrial publicity. The other sample was recruited from a different region so that exposure to pretrial publicity could be experimentally manipulated. Guilt ratings were assessed at several points in time during the trial. Despite admonitions to refrain from using pretrial publicity information in their decision-making, similar to instructions given to actual jurors, mock jurors continued to be influenced by pretrial publicity all the way through to their post-trial verdicts. Their initial impression likely served as a filter for how they received subsequent trial evidence and arguments, consistent with confirmation bias and belief perseverance tendencies, causing their bias to persist even after all evidence was presented. Attempts to mitigate juror bias. Research has yet to determine a reliable method for eliminating pretrial publicity bias effects after exposure has occurred, suggesting that limiting potential jurors' exposure in the first place would be the best avenue in the pursuit of a fair trial. This is why change of venue and non-dissemination orders have such importance. Screening, questioning, and instructing jurors. Although this research is limited, some work finds that even extended voir dire by seasoned attorneys do not specifically mitigate pretrial publicity effects despite its other potential benefits. Selecting jurors based on prior exposure. Psychological research would point to at least two problems which limit the ability to select jurors who were not exposed to pretrial publicity. First, prospective jurors may not consciously recollect their exposure. Some of their memories are unconscious. We do not know the memories are there, but can still affect us. For example, someone may not remember that they learned something negative about someone, but they still have a negative impression of that person at a conscious or unconscious level. Several decades of research have shown that our judgments can be influenced by information in our unconscious mind. Hidden memories may also become conscious if something triggers them during trial. Thus, a juror may report not having been exposed to pretrial publicity, but then later remember some specific publicity exposure after something during trial reminds them of the memory. This process is called priming. A second problem is that prospective jurors may not be honest about their exposure, perhaps due to social desirability concerns, wanting to appear favorable, or conformity pressure going along with real or imagined social pressure. Selecting jurors based on ability to remain impartial. One problem with the approach of asking jurors if they are able to remain unbiased is that although they may take due process seriously, people may be unaware of their biases and thus unable to correct for them. Most, if not all, of the effects discussed in this report occur automatically and beyond people's level of awareness. For example, when people's opinions are biased by pretrial publicity information, they tend to deny any such influence. At a minimum, awareness of one's own bias and the motivation to overcome it are prerequisites for controlling bias effects. However, even when warned about the potential for bias, jurors are often incapable of ignoring any prior judgments or preconceptions when evaluating evidence from a trial. Additionally, some people may think they are incapable of unfair biases. There is a tendency to recognize bias more in others than in oneself, which is known as the bias blind spot. This is unsurprising given that people generally tend to overestimate their abilities and underestimate their weaknesses. This self-enhancement bias has been documented time and time again in peer-reviewed research. Because people tend to view themselves as less biased and less prejudiced than others, they may feel unnecessary to be attuned to and correct for the potential flaws in their judgments. People also have an overconfidence bias, wherein they overestimate their confidence regarding their judgments, perceptions, and decisions. For example, one study found that when people say they're 100% certain of something, they are incorrect, on average 20% of the time. These areas of research suggest that one cannot simply ask jurors if they are capable of being bias-free when evaluating a case, and then choose those who say yes. In fact, that may result in a group of jurors with even more inflated self-perceptions and even less awareness of their capability of being biased, which equals a more biased jury. This is consistent with research showing that people who have the highest level of sexism or racism also have the most favorable distortion regarding their egalitarian tendencies. Thus, people are typically unable to make determinations regarding their current level of bias their inclination to be biased when evaluating new information, and their ability to control their biases in cognitive tasks. Judicial instructions to disregard information. Several decades of research have investigated whether instructions to disregard evidence are successful, finding that such instructions typically do not work and can even backfire. A 2006 meta-analysis examined the effects of instructions given to jurors to disregard inadmissible evidence across 48 studies, concluding that when evidence is presented, verdicts become more aligned with that evidence even when jurors are asked to disregard it. This was also true when examining as a whole the subset of studies which specifically involved instructions to disregard pretrial publicity information. Other research found such instructions to be ineffective in offsetting the influence of both factual pretrial publicity, incriminating evidence, and emotional pretrial publicity that was not evidence-based. Studies have shown that getting jurors to pledge impartiality and agree to refrain from using prior knowledge does not eliminate bias from pretrial publicity. Because law enforcement may have a lot of detail regarding a case, they could inadvertently supply the media with information or evidence that is later deemed inadmissible in court. Unfortunately, the most reliable solution for preventing bias among jurors is the prevention of exposure to this information in the first place. Jury deliberation. Just as the presentation of trial evidence and arguments does not eliminate pretrial publicity effects, neither does jury deliberation, as observed in mock trial studies. In fact, deliberation may increase the effect of pretrial publicity. Recall from the 2022 meta-analysis that the effects of pretrial publicity were stronger when examining group verdicts versus individual verdicts. Although most studies examining post-deliberation effects in groups have typically exposed all jurors to the negative pretrial publicity information in the experimental condition, which might be a rare occurrence in real-world situations, some have examined mixed juries, where only some members were exposed. A 2017 mock jury study showed that in mixed juries, the biases among those exposed to pretrial publicity can spread to other jurors during deliberation. Subsequent experimental research in 2021 yielded the same result, showing that if some jurors were exposed to pretrial publicity information, that information can steer the discussion in the same direction, for example, anti-defendant, during jury deliberations with jurors who had not been exposed, ultimately affecting post-deliberation guilt judgments. Thus, deliberation is not seen as a method for eliminating pretrial publicity exposure effects, and can even worsen them because it provides a means to spread information to jurors who had not yet been exposed. Moreover, group discussion tends to cause a group's initial leanings become stronger or more polarized after group discussion, a widely researched phenomenon known as group polarization. Thus, if some jurors have initial leanings that are anti-defendant, that could be enough to influence the overall group's initial leaning, ultimately resulting in even more anti-defendant views post-deliberation. Group polarization effects have been confirmed to exist in mock juries. My conclusion from the review of the research is that pretrial publicity effects on judgment tend to affect judgments of guilt and are pervasive, lasting through trial, and hard to reduce. As such, the best way to prevent them, based on our current knowledge base, would be to utilize jurors who have not been exposed to coverage. Because of the difficulties with asking jurors about their exposure, a better approach would be to limit the information presented to prospective jurors until a fair trial is held. Although a non-dissemination order does not prevent all exposure to pretrial publicity, it should limit both the quantity and type of information in ways that should result in less bias among prospective jurors, increasing the probability of a fair trial. For all the reasons noted in this report, I recommend limiting the amount of pretrial publicity presented to prospective jurors, particularly the types that might carry more weight or be distributed more widely and repeated more frequently. Respectfully, the doctor. Let's try this. See if the audio works. I have not seen this yet, so can you hear? What on earth? Mm, I mean, can you hear me? Yeah, I'm clicking. I'm clicking the thing that says share tab audio. Let me see. I almost feel like it's Microsoft Edge. Like it always gives me problems. I am going to pull it up in Google. Let's see. I hate Microsoft Edge, but for some reason it always like defaults to it. You guys, what the fuck?
All right. Thanks very much. Please be seated. Good afternoon, everybody. Okay, let's sit on the record, please.
You can hear the hearing?
We are now on the record, State versus Bryan C. Kohberger, CR 29222805 in the courtroom. Mr. Kohberger is in the courtroom with his attorneys, Ms. Taylor, Mr. Logston, and I'm sorry, I missed you because you were behind the screen earlier, but also Ms. Massa is also present. Representing the state is Mr. Thompson and Mr. Rudley, and we're really here for the motion associated press et al. I'll call you non-party media coalition. So if Ms. Olson and Mr. Carone could come up, or I don't know if it's just going to be you. Ms. Olson?
I would be the only one arguing, Your Honor.
Okay, well, thank you. So we have a lot of things to sort of sort through. And I know some of your clients are listening on Zoom, and I can't look at all of you while I'm looking at here, but I just wanted to acknowledge that. So I think we probably need to start with the motion to intervene. But let me just tell you my thoughts about that. I think that after reading the Supreme Court's decision, the coalition has standing, and so I think you're entitled to be here and make the argument. But I don't know that I need to grant intervention. But I don't know, what's your view of that?
Your Honor, we think just to have the clearest record possible, that the court should grant intervention for this limited purpose. We think that would frankly also be helpful should the situation arise again, since there's simply no rule that sets out whether we can do this or not, which is among the reasons we went the wrong place the first time. So we would ask the court grant the motion. I don't intend to offer any of the argument other than was offered in the briefing round.
Okay, let me go to Mr. Rudley or Mr. Thompson.
Your Honor, we don't have an objection to granting the motion to intervene for the limited purpose of challenging the amended non-discrimination.
Okay, Ms. Taylor?
We don't have an objection.
Okay, great. Okay, so I'll grant that request for the limited purpose. The reason I was worried about that is I don't want the media to be really, so to speak, a party that has to be involved in so many things that we're going to be dealing with. So, but I will grant that request for the limited purpose of what we're talking about here.
Thank you, Your Honor. And then there's just one other housekeeping matter. As the court indicated, some of our clients in the coalition are participating by Zoom. They have been informed and directed that they may not record the proceeding that's occurring by Zoom, but they may report on it after the fact, just like any reporter here in the courtroom, or as if they were with us here in person as our party representatives.
Okay, agreed.
Thank you, Your Honor.
All right. The next issue, though, is this motion for shortened time. I didn't sign that proposed order. Apparently, there's an objection, and let me hear from you first about what that might mean for what we're going to do today.
Well, Your Honor, I think given that the hearing has been scheduled today, that the court hasn't, in essence, granted the motion to shorten time unless it would be allowed. You'll just slow down. Yeah, sorry about that. I think the court has indicated it's going to grant that motion. We're having the argument on it today. I think the one potential sort of hiccup there or sticking point there might be with respect to the evidence that Mr. Kohberger wants to introduce, to which we do object, given we became aware of it 3 days ago, and there simply hasn't been enough time to vet the information that they seek to provide. And as we set out in our reply brief, we think it's not appropriate anyway, given it's time for them to have introduced evidence in support of the gag order that's in place was in January of this year. So I think that might be the only sort of hiccup with respect to whether the court might end up shortening time or giving them additional time to present that evidence.
Well, I haven't approved the shortened time because I wanted to hear from counsel how they viewed that. I know when I talked to Mr. Crone last time, I was concerned about the short time, and I was really, maybe it wasn't very direct, but encouraged that we allowed a little more time because I know there was going to be a lot of briefing. At that time, I think Mr. Logston, said that it's going to be for us to get things is what I meant. And so here we are. I was also concerned about I had to go through very quickly, which I did. And I want to make sure, because this is a very important decision, that everybody has the opportunity to weigh in with what they want to present. So maybe I should go to Mr. Logston and see,
May I offer one other comment?
well, yes, go ahead.
Your Honor. So, Your Honor, I understand, I think we all agree that this is an important matter to address, and that there are significant interests at stake among both the parties and then the interveners. And I think our concern in wanting to move it forward sooner rather than later is that this gag order has been in place since January, since virtually the inception of the case, and it has rendered harm to our clients' interests. And so that's why we wanted to move forward more quickly. And that's why we had offered, we thought, as sort of a interim step. And we were at the hearing this morning, we heard your comments to Mr. Logston at the end, but that's why we had sort of offered as a interim step, vacating the gag order pending a more fulsome evidentiary hearing.
By the way, I mean, just so you know, I find that to be a very kind of inaccurate and distasteful name for the order. And I had trouble about that for a long time, and it's not called that. So I would appreciate not using that term. It's distasteful, and I think it's inaccurate, and I think it's been overstated, just the impact of that order, just to let you know.
Thank you, Your Honor.
Okay. Well, and so you are, why don't I go to Mr. Logston and we'll see how we feel about the presentation of the evidence and or expert testimony. Go ahead.
Your Honor, we have two witnesses. We also filed, as I'm sure the court is aware, a motion that we believe the court has the ability to take judicial notice of the media coverage in this case. The media, as we understand it, is essentially objecting to there being a record made at this point. Our stance is this is a live issue, and this will not stop being a live issue so long as our client is in this case. And as the facts, we're even announced in the United States Supreme Court case to come down a year from now, it changes too. But as things change, everyone has the right to come into this courtroom and say, we'd like to have the non-dissemination of it reconsidered, amended in ways that are going to match with what's actually happening. The media has made the point that when this originally was put in place, it was just the parties agreeing that we wanted to make sure that we were doing everything in court and not doing it to the press. And so we didn't, at the time, feel the need to make a big record about what was going on. At the court mentioned that to some extent what's going on is so obvious. And while we would concur with that, given the media's point and given some of the case law out there, we thought it would be wisest to make a record at the very least of the amount of coverage, of the consistency of the coverage, and to some extent of the substance of that coverage. And that's what we associated with you talking about from company TrueScope. And then we also brought in a psychologist, professor of psychology from Eastern Washington University, to basically just kind of talk about why we care. I mean, and there are reasons we care that we talked about in the brief that aren't related even to the biases and things like that. We just have overall concerns about, as a country, how do we resolve these cases? Is it in the press or is it in a courtroom? And those are issues that we don't necessarily need these witnesses to get to. But to the extent that the United States Supreme Court has clearly shown that we do concern ourselves with the effect on jurors, even the effect on ourselves and our witnesses, that we brought in a social psychologist who can explain what those issues are a little bit better than we just sort of understand. In terms of, our position is that the court needs these things. We think that they're best to make the record in the case. And I think the court is correct. We thought it would be better to have more time so that everybody could take their best shot. I feel like we did a pretty good job of warning everyone that we were going to be bringing witnesses today. Yeah, but that, at the same time, I mean, like I said, it's a live issue. The court could issue something today, the media could go back, find themselves an expert that they think blows our whole case out of the water, and then come right back to court and say, well, let's do this again. And that doesn't make any sense to me. So I certainly don't have an issue if the media decides what they'd like to do is have additional time to find their own witnesses, for that matter, to prepare more. We're not going to object to any requests to move this here.
Thanks, sir. Mr. Bradley, you
Oh, Your Honor,
addressed that. Maybe you want to come up for the mic.
Oh.
Thank you.
I'll be brief, but the state has no position on the motion to shorten time or hear additional evidence.
Thank you. All right, so Ms. Olson, I'm going to back up. I'll tell you where I am on this. Well, number one, I agree with Mr. Logsdon that this is a moving process, and analyzing this going back to whenever it was imposed is not particularly relevant at this point. A lot of other things have happened. If there was no order in place right now, I could impose it today based upon the evidence that was presented. But there's not really any evidence presented yet, and that's why I asked for potential evidence to support the record. I mean, I think we can probably agree that this is a high profile case. There's a lot of interest. There's a lot of misinformation and disinformation out there in the public, and that's quite concerning. My job is to protect the First Amendment as well as the Sixth Amendment, and there is a balancing in that. I don't think there's any question about any of that. So I'm inclined to allow, the testimony and the evidence. I'm inclined to take judicial notice of the submission of Mr. Kohberger, but I am happy to put this out to give you and your clients an opportunity to respond to that, because I know it's incredibly short notice.
Thank you, Your Honor. It's 3 days notice, but we can readdress some of that. We prefer to go forward today. And as Mr. Longston just acknowledged, if we feel like there's evidence to be found later, we'll probably just file a motion to reconsider it. And I would just like to address one point here. We understand that things evolve, and we're at a different point today on June 9th of 2023 from where the two parties were on the first, I think, January the 3rd, and then with the court in chambers with no court reporter taking down anything that happened, where you had to file a redacted memo, and then the amended non-dissemination order came out. We understand we're in a different place, but our point is that the court entered that without any findings of fact that warranted such a non-dissemination order that was what we assert is the order in place now was overbroad and was procedurally deficient. And that's where our concern is. There is a First Amendment harm that occurs from a non-dissemination order that is overbroad and where there was simply no opportunity for anyone other than the parties to weigh in behind closed doors with the court. And I was here this morning, and so I heard Mr. Gray say that he disagreed with the record that's been made on that. But I think that's a significant concern, and that the court should be concerned about the procedure that was used initially to enter that non-dissemination order. And that's why we continue to take the position that if the court feels a more fulsome record is needed, that the order in place is simply not justified by what the court did back in January, and it should be vacated pending the development of that more fulsome record, Your Honor.
Whether that's accurate or not, I mean, that's why I'm inclined to allow any of the parties and the media to add to the record. I just want to remind everybody, this initial order was an agreement. It's a stipulation. It wasn't that Judge Marshall just pulled it out as, air. It was an agreement between the parties. There are only two parties to protect the Sixth Amendment. That was the reason for that. And I would note, because I think this is missed in the discussion, that this was going heavy well before Mr. Kohberger's arrest. So there was a lot of speculation, a lot of criticism, a lot of bad information, and that would trigger for any lawyer for either side to try to protect the integrity of the investigation and the future court process. So just try to, I do think that this thing has kind of grown a bit out of proportion from where it started and where it is now. Because obviously, if you look at a newspaper or the TV or YouTube or TikTok, or I don't look at any of it, but the media has freely talked about this case. So I think that's really kind of the issue. Like, do we have a responsibility to talk to the lawyers about releasing information that shouldn't be released to the public, and allow the media to follow the rule of, or the First Amendment freely, which they have. What I hope is that they do it responsibly and professionally and accurately. But that's really up to the media. I can only control so much, and you can control only so much of your clients and other media and media that are not traditional. That is really the struggle, and that's why the order was entered originally. Just to give you some background.
Understand, Your Honor, and I would ask my good friend Bill Thompson if I can have a lot more. Sorry about that. Well, I think interviewers well understand why the parties did what they did and the interests of the parties in this. Interviewers well understand. You're frankly for Mr. Thompson, and I've been in Mr. Thompson's position in the capital case.
I know you have, and I know you understand the issues here, and that can collide.
Right, and what we know is that the state wants to ensure that its investigation, or that in the case that its investigators and its prosecutors put together and presented to a grand jury and obtained an indictment, that they can present that case the strongest way possible without having to worry about external events, and certainly external events they can't control. And we know that Mr. Kohberger and his counsel have a tremendous interest here in fighting for his freedom and likely fighting for his life. They heard the court earlier today, and I think all of us who have practiced in this area at all know this is likely a death penalty case, but that, those are not decisions that have been officially made yet, and it hasn't been put before the court, but that's why Ms. Massoff has been appointed to help represent Mr. Kohberger. She's an excellent attorney. I know her well. She will do a very good job for him. And I know that they have an interest in making sure that when it comes time to pick a jury, if this is a case that ends up going to trial, that they can pick jurors who will fairly and impartially hear the evidence and make a decision based on the things that they hear from the witness stand and not based on what they see on Twitter or the internet or watching the news. And that is a fundamental interest of this entire system, which frankly I spent most of my career working in.
Well put. Thank you.
But there are also, this court has tools in addition to non-dissemination orders to make sure that there is the best chance to get a fair and impartial jury when this case is heard, aside from a non-dissemination order, which I'll come back to the parts where I find to be overbroad and not having been procedurally accurate. There's probing voir dire. There are jury questionnaires. There's a change of venue. There will be the passage of time, and I think that's where this is a potential, because this is a potential death penalty case. That comes into play. If the state files a notice of death penalty and it becomes a death penalty case, I would be stunned if this case went to trial on October the 2nd of 2023, because the defense will need to do a mitigation investigation. The defense will need to look at experts from a host of areas who will be able to present evidence about Mr. Kohberger, his life, and why the aggravating factors that would perhaps the state would argue for, why those should apply, and why the jury should choose a different sentence if it gets to that point after a guilt phase. That takes a substantial period of time, years in many cases. And the passage of time, I understand, we've looked at all of the materials, not very detailed, the materials that Mr. Logsdon submitted from Ms. Saucier and the professor from Eastern Washington. And we understand that there's a lot of publicity now, but I will tell you one of the things that was most surprising in the Duncan case, and I gotta say also, when you're doing a big case like that, you're just living that case, you think that's all anybody thinks about. But the most surprising thing to me when we picked the jury in the Duncan case, 3 years after the murders, was that there were people who hadn't even heard about it. And that's a case where, granted, the trial there happened in Boise. That's a case where, you didn't have social media yet to the same extent yet. But there were cars in Coeur Lane driving around with "Kill Duncan" bumper stickers. And there was a donut shop that had on its magnetic reader board, "Kill Duncan." That's pretty prejudicial pre-trial publicity, and those things would get picked up in the media. So that passage of time, with the probing voir dire, the questionnaire, and the change of venue, all did a lot to ensure that there was a fair and impartial jury that was impaneled. And so those tools we would submit are available to this court. Because in addition to the very important interests that Mr. Kohberger has, and the very important interests that the state has, and I think as Mr. Ledley acknowledged this morning, the state also has an interest in ensuring there's a fair trial. The media does have an interest in enforcing or fulfilling the dictates of the First Amendment and the free press. And those are equally important principles, at least at the stage of beginning to weigh them, Your Honor. It's through the members of the media and the press that the public learns about these proceedings, that the public is able to understand how the criminal justice system functions, that the public is able to understand how the prosecutors perform, how the defense attorneys perform. That's how they learn about details of the investigation when they're released, either in the courtroom or released through the probable cause affidavit, so they can make their independent judgments on how is our system working, so they can be educated. Just as the court did this morning when it started the hearing this morning by pointing out and explaining why someone would come into court and not enter a plea when called upon to do so, when the court has to enter a plea for them. And those who have been in the criminal justice system have seen that before. So it's that kind of educating that can be done by the court, by the people who actually know about the proceedings. I see no reason why after that proceeding, Mr. Thompson might not have been able to, or Mr. Lawson and Ms. Taylor, been able to answer a question about, wow, well, that's unusual. Can you really do that? And someone say, well, actually, under the rules of criminal procedure in Idaho, or under case law in Idaho, you actually can just not stand silent and not enter a plea, and then the court has to enter not guilty pleas for you. That would have been a very helpful thing to have done. And I think it is educational things like that that can be relayed through the media, that the current non-dissemination order restricts these attorneys you're speaking about, or really any attorney, because it's the way it's phrased, any attorney with interest, for a party with interest in the proceeding. That's pretty broad. That's extremely broad. It's not just Mr. Thompson. It's not just Mr. Lobson, Ms. Taylor, and Ms. Nathoff. What does that mean to be a party in interest in the proceeding? We talked about the motion to intervene, but we wanted to make sure it was a limited purpose so that we suddenly don't become parties with an interest in the proceeding. And then I can't walk outside and talk about what went on in court. So Your Honor, what we're asking for is the court also to look at what is the First Amendment, what role does it play in the court's analysis? And how can it balance those First Amendment rights and use those other tools that are available to, particularly at this stage of the proceeding, to ensure that the Sixth Amendment right is observed and that the First Amendment right is observed. And we think, Your Honor, in doing that, you have to take a look at the non-dissemination order and apply strict scrutiny analysis. And there's lots in the briefing about strict scrutiny analysis. We think the court gets there 2 different ways. One, because we view this as a prior restraint. In order to have news or publication, you have to have not only print the information, but you have to be able to receive it. And if you can't receive it, you can't present it to the public.
Is there law on that?
There is, Your Honor. There is, Your Honor. It's in our briefing. And I would ask the court to take a look at pages 15 and 19. It's not in one of the big 3 Supreme Court cases we've all talked about. It comes primarily from the Young case, but that's where that comes from. There's nothing in those 3 Supreme Court cases that says that you don't apply strict scrutiny when it's a restraint on something other than the media, other than perhaps the Gentile case where it says they're talking about the lawyers and it says that you still have to be able to show that it's prejudicial publicity. And then you have to have a narrowly tailored tool that's designed to restrict it. And Your Honor, regardless of what the test is, there has to be prejudicial pre-trial publicity. Publicity that could prejudice Mr. Kohberger's right to a fair trial. So publicity generally, and I think this is where Mr. Lawson submits Ms. Sausier's information, there's no reason to think that publicity generally is prejudicial. It's a publicity about the case, and it allows people to hear about the case. But some of the things people are hearing about the case may not be all that flattering for the state. It may be not prejudicial to Mr. Kohberger. It may suggest things about the investigation and how it was done. So publicity in and of itself is not prejudicial. And that's why I think when we get to what is out there, that courts typically rely on first blush is Idaho Rule of Professional Conduct 3.6. And those 9 items of what attorneys for parties in the litigation may not comment on. Those are rules that are vetted, and they're the same as the ABA rules and the basic rules that every lawyer has to follow about. You can't, if you're a prosecutor, you don't get to walk out of the courtroom and say, well, in this case, we've got the guy because X, Y, Z, whatever. And if you're, you just can't do that under the rules of professional conduct. And there's no reason to think any of these lawyers, who all are fine officers of the court, are going to ignore their obligations under Rule 3.6. I understand their desire and their interest in having something more prophylactic so that they can operate in a way that doesn't, so they frankly just don't have to worry about that. But it's our position that the First Amendment requires more and much more, and requires a narrow tailoring. And that when you have a non-dissemination order that starts out and says all extrajudicial judicial statements, it cannot be made. And
I can fix that, can't I?
Sure.
I mean, so if I just, and I kind of raised this morning too, that if I am more specific about who is touched by this order and what can people say and what can't they say, then that would help your concerns, wouldn't it?
It would, Your Honor.
And I'm acknowledging this because your motion is to completely vacate it.
Absolutely, Your Honor. And the reason it's to completely vacate it is because we don't feel it's narrowly tailored. And so a overbroad, non-narrowly tailored order that, and I respect what the court said about procedurally how it came into place. That might be one where we just have to agree to disagree. But it's our position that such an order should not be in place. If the court then wants to enter another order, then it has to do something that is designed to address or limit substantially prejudicial material, prejudicial pretrial publicity, and make sure that it's narrowly tailored. And that's why I think Rule 3.6 continues to sort of be the guiding star on that, because it lists the things that tend to be most prejudicial. And so certainly, if the court takes a different approach, we will look at that, and we would certainly hope that the current order we think is overbroad and procedurally deficient. And we recognize the court's ability, to hear all that's going to hear, and if it chooses to craft something and still thinks one is appropriate, obviously we'll take a look at that and see whether we think it still suffers from the same deficiencies as the current amended non-dissemination order. I would also say, Your Honor, because I heard your questions to Mr. Bryan.
Yeah, I'm glad you're here. I'm glad you're here. So, yeah, you might want to address.
And so this would be our position with the concept generally, setting aside, our position that it shouldn't be there at all. But I think that limited to Rule 3.6 is palatable, at least because that's the obligation that the lawyers on both sides already had. I think it would be very difficult to then have a list of things that you could say. You could say this, but you can't say this, because then it would be impossible to think of every possible statement that could be made. But if there's clear direction on the statements that cannot be made, and they are the things that are set out expressly in Rule 3.6, that gives very clear direction, is consistent with the Idaho rules of professional conduct, and would leave sort of no guessing for the people who do want to provide adequate guidance and information. And then we would also ask the court not to do something about the language that says attorneys for all interested parties. I think, frankly, that's sort of just inherently vague as to what that means. And when there are very specific parties here before the court, I think the court could really narrow that a tremendous amount. And I heard the dialogue this morning with Mr. Gray regarding witnesses, and I will say, Your Honor, that's obviously not. I think our preference would be witnesses not be included. But when one looks at, for example, the family member witnesses and the fact that they may be called, certainly if there is a sentencing phase of this, and they may be called by the prosecution to show victim impact, to provide that information. There's very detailed law on what you can have a family member say in a capital sentencing hearing. And it's usually the kind of thing that is, my child was a great kid, they brought, there was a lot of everybody's life. Here's the video of them dancing at their, 5th grade Christmas program. And that sort of thing. It's not details about the case. So for those reasons, we would think something that restricts witnesses who are not going to be fact witnesses in the guilt phase, we think that would certainly be overbroad as well.
Okay, so let's go back to, because we kind of, that was great. Thank you. I appreciate everything that you said. That, I am going to grant the request to present the evidence, or I don't know, just the submissions, we'll just say, and take judicial notice of that and allow for the testimony. But you will have an opportunity to come back if you choose to do that.
Well, I'll probably do some cross-examination today. Probably won't be as tight as it would be if I had the opportunity.
Absolutely, you have the opportunity to do that.
And I think, Your Honor, just to be clear, we made some arguments in our reply brief about why these individuals are not the experts. They would never qualify as experts under the federal rules of criminal or civil procedure based on the things that they list in their CVs and their prior work. If they're only offering this associated to say there's lots of publicity around this case, I don't think anyone's going to disagree with this. But I would point the court to now, and then I don't know if Mr. Lawson asked her about this on direct, but in her report, and she's got some little tables, and it's not, the version we have is not tabulated, but there are two tables, and one says authority figures share a voice, and then non-authority figures share a voice. And on authority figures share a voice, one of the people that's listed on there is David Nye. I don't know why David Nye is someone that they're saying is an authority figure on all of this. David Nye is a federal district court judge in Idaho, as the court was. Maybe they meant Jeff Nye, who I think is assisting Mr. Thompson, but that's, I anticipate is an error in the report. And then if you look at the next page, at non-authority figures share a voice, and then share a voice media coverage, the person with the greatest stories in the data set is Rebecca Boone, who's an AP reporter, and then the same thing with shared voice media coverage. And of course, the AP stories run all over the country and they get shared in different publications. So I suspect that might be one of the things Ms. Salce will say about that. But the definition she uses in her key terms defined is authority figures are experts who are currently working on a case. Authority, that's too much caffeine this morning. Authority figures are experts who are currently working on the case. Well, David Nye is not currently working on the case. And then non-authority figures are, per definition, experts who currently work in or formerly worked in the field of law enforcement, police or FBI law, such as lawyers or other court-related personnel, but who are not working on this case. Rebecca Boone isn't any of those things, and she's the primary person they put forward in that area. So if the court wants to consider that, I mean, I think just right off the bat, there are a number of things that make it inherently unreliable.
Let me just be candid. I mean, I'm not going to put a lot of weight on that because as you said, starting out is, I mean, there's no question about how much information has been poured out about this case. I'm allowing Mr. Kohberger to make a record, okay, because that's something that that has been raised by you and your clients, that there's not a record to support this, to justify it. So I feel an obligation to let everybody weigh in with what they think justifies an order. And I don't disagree with what you're saying about narrowing or being more specific. One of the questions I heard you talk about prophylactic, and I think that's an interesting question when you talk about other options to deal with a fair trial. Going to another venue, for example, or sequencing.
Sequestering.
Yes, thank you. That is complicated. It's expensive. It's time consuming. And so if we can be prophylactic about it by limiting, okay, what lawyers who have a different standard, okay, lawyers who are actually directly involved in the case have more credence, okay, in the public. And that's a reason to restrict that. And that's why I don't like the term gag order, because nobody's really gagging about it, okay? These are lawyers who already are restrained by ethics and professionalism. So that's really what we're talking about, to kind of do what we can, even though I don't even think the media can really control all the information that's going out there every minute, right at this moment. And so this is not the same world as it was 10 years ago or 5 years ago. And it is troubling for the media, the ethical, hardworking media, and the information that's swirling around in the world. I don't know what the answer is, but it's a serious threat to a fair trial and the credibility of media. It's just a side speech. I apologize.
And I'm not sure that anyone would disagree with that. I mean, we live in an age where finding out what the facts are is more and more difficult with every day. And both the participants in this criminal justice system, the court, lawyers for any party, and the members of the media, we all participate in systems that are designed to be fact-based, and that are designed, when they function well, to get the information out that's truthful and accurate, and through a process that is most appropriate. And I don't think anyone would disagree with you, Your Honor, that right now, that there are certain, because everyone can have a blog or be on Twitter or be on, and there are so many social media channels out there now that a person my age does not hardly know any of them. But those are all certainly out there. And no order from this court, respectfully, Your Honor, is going to reduce any of that. But when there's an order from this court that limits the ability for people who have actual facts and good information to provide statements about things like the court this morning, they can educate people about the process. Certainly, no one's expecting that Mr. Thompson or Ms. Taylor or Mr. Logsdon or Ms. Massoff are gonna, if the court lists non-dissemination order, are gonna run out and tell you everything they know about this case. They're not. And so I think, Your Honor, when you are, if the court, it sounds to me like the court is inclined to have some sort of Second Amendment non-dissemination order, I would urge you to make it as narrow as possible so that the actual facts can be relayed to the members of the media. And I think when you look at who the media coalition is that came before this court, I mean, this is a group of Idaho-based, some Washington state-based. It's hard to be in this part of the state of Idaho and not be completely familiar with Washington, and then some national outlets that continue to have an outstanding reputation. And what they want is for their reporters to be able to obtain accurate information and information that is of the kind that is not, they understand the things that probably the lawyers are not going to tell them, but information that might help the public better understand all of this. Because the other thing that is just so, is the background of all of this is these are tragic events that affected this community, the entire state of Idaho, and there's probably nobody who doesn't know, you and I know who doesn't know someone in Moscow who was affected by this tragedy. And I think as part of that, and there are people who really have an appetite for accurate information about this case. And what we would ask this court is not to have any sort of non-dissemination order that restricts the public's ability to understand these proceedings and to get accurate information.
Okay, so thank you. What I would like to see, maybe we all like to see, is the media actually doing more complete analysis of process, okay, and explain to the public why we do what we have to do in protecting a fair trial. I haven't seen any of that. Now, I'm not out there following the news carefully. I think our local press has been really fair and pretty balanced, and I appreciate that they are talking about some of the details and explaining kind of why things are happening. It would be nice to see more of that instead of the sensationalizing that we are seeing in the national media. So, and by the way, I haven't made a decision at this point. I mean, when I ask questions like this, I'm testing my thoughts about where we might end up. So I don't know if you want to address anything else about the evidence or further your argument. I kind of interrupted you there.
No, I think we made it all the way through the things that I had planned just to tell the court about the standard it should use to analyze this, the reasons it should vacate the current non-dissemination order, and there are thoughts on if the court is inclined to look at a different measure to ensure a fair trial, that it use some of those tools that are available to it other than a non-dissemination order, particularly when realistically the trial in this case is probably at least 2 years out because of all the things that the defense will have to do if this is a capital case, and they'll do it well. And we don't do that in about 4 months.
That remains to be seen.
I understand.
I understand what you're saying,
Yeah.
too. So, and you're sticking to strict scrutiny.
Yes, Your Honor, I think for 2 reasons, Your Honor. The first is that because we view it as a prior restraint, and because in order to both, it has to be, in order to report information, you have to be able to gather information. We direct the court to page 15 of our brief for that. And then separately, Your Honor, when the court is balancing two competing constitutional rights, we would submit that the court has to apply strict scrutiny. I think that's on page 19 of our brief. And then finally, I would say, Mr. Wellington submitted a bunch of materials to the court. If the court's inclination is to sort of give them the weight they deserve, I'm not sure I'll spend a lot more time on it, other than I wanted to point out there's 2 quick errors that I was able to find in Ms. Salcier's tables. But we submitted declarations from reporters who I think their experiences illustrate sort of what happens when you have an overall non-dissemination order like this, where people who really are not involved in the proceedings, people who are being asked about topics that aren't really directly related to the facts of the case, they're citing the non-dissemination order for reasons they can't talk to the media. And that just, I think, sort of reinforces why you're going to get the things that we see on social media and the internet and the things that the court will express concern about.
Well, let's just, one of the problems there is, I think that a lot of the media were suggesting that the order was much broader than it actually was. And so maybe people responded to that. The other option would be that they were just using it as an excuse because they didn't want to talk to a reporter. And that's their right?
Absolutely, Your Honor. That's what they said to the reporters, and that's what those reporters said in their declarations to the court.
So let's just say, just for the sake of discussion, that if I just lifted this order, what are you after that the media doesn't already have? You want to be able to talk to the prosecutor? You want to talk to the defense attorney? How far does that go? You know that you just can't open their files.
Absolutely. It would just allow them, it would allow Mr. Lawson, if he wanted to respond to a question in the manner that he did in court today about why Mr. Kohberger stood silent instead of mentioning please, it would allow him to respond. It might help them describe what's going on in the court. Something happened in court today, and can you explain what that term means? Things like that. It happens pretty routinely in lots of other criminal cases. It might also then take away these law enforcement agencies in other locations who are reluctant to respond to public records requests because they're concerned about running afoul of a non-dissemination order issued in another state. There would simply be better sources of information available to reporters. But again, everyone would still have the opportunity to say, I choose not to speak with you. But they wouldn't be prohibited from doing so by the court.
Thank you.
Thank you, Your Honor.
Okay, good job. Appreciate it. Let me go to Mr. Rudley or Mr. Thompson.
Your Honor, the parties discussed Mr. Logston making his presentation first since it's more substantial.
Okay, Mr. Rudley.
Well, we do things a little differently, I guess, of course, because I'm used to putting the evidence on and then we argue on it. Now I'm a little thrown because we had argument.
You can go ahead and Ms. Olson can come in and question if she wants.
Okay.
We didn't know until we were kind of halfway through the argument about what we were going to do with it.
I understand. So I think I'd like to start by moving the court to take judicial notice of the press materials that we provided and essentially have the court acknowledge that it has the power to take judicial notice of the press coverage in this case.
I'll do so over objection.
Thank you, Chair. And then we'd like to call Ms. Jean Saucier. She is available via Zoom.
Your Honor, you may have been
Yes.
suggesting this,
Come on
but
up.
may I come back up to
Yes,
this?
come on up so we can hear you.
All right.
Thank you, Ms. Olson.
And may Mr. Colon come up as well, so if.
Sure. Come on up, Mr. Graham. Thank you. Okay, so I Saucier, is that right?
Yes.
Ms. Saucier, could you please raise your right hand?
Do you solemnly swear or affirm that the testimony you give in this case shall be the truth, the whole truth, and nothing but the truth under penalty of perjury?
I do.
All right. Thank you, ma'am. Could you please state your name and spell your last for the court reporter?
Yes, Your Honor. Jean Saucier, SJEAN, SAUCIER.
All right. Thank you, ma'am. Mr. Logston?
Associate, how are you employed?
I am employed with a company based in Nebraska, headquartered in Nebraska, called TrueScope.
And what is it that that company does?
TrueScope is a global media monitoring and measurement company. We provide media intelligence data.
And how long has TrueScope been doing that?
TrueScope has been doing this for 3 years. The company that I worked for previously was acquired by TrueScope. That company was Universal Information Services, and that company had been performing media monitoring and intelligence services for over 50 years.
What does that mean, media monitoring and intelligence services?
What that means is that we, companies such as ours, provide data to corporations, organizations, both in the profit and nonprofit world, to show what's being written about or talked about or communicated about their company or other types of maybe projects or things that they're working on in the world. And it shows media companies pull in that data to show return on investment for maybe a for-profit company or other key messages that are being written about or talked about.
And approximately how many clients rely on that service right now?
Currently, we have about 270 clients throughout the world.
And when it comes to how are you able to collect this data? Is it like an algorithm? How does that work?
So it is, there's a lot of technology behind it, but sort of broadly speaking, the way that our system works is it will ingest content. We have licensed data sources that provide to us content via API. That content is pulled in from all media types, from broadcast, print, social, web, and that is pulled in via API. And then where that content is housed and stored for the front end of a web platform where our clients can review that data, filter that data, chart that data, and that's how they can see what those messages are and where they're sort of going to have a gauge on the important content of what they need to see.
And what's your role in this?
My role at TrueScope is I've been with the company TrueScope, previously Universal Information Services, for almost 8 years. I'm Senior Vice President of Client Success.
And in that position, what kind of knowledge do you have of the way in which the company performs its task of collecting this information?
So I am very involved in the customer support, training, onboarding, client demoing. Demos, something that we do to
show what the platform looks like, what it can do, the capabilities, the features, functionality. I also lead the team that provide and produce curated reports. We do that for media insight, and we do that for executive daily news briefing.
And what's your understanding of how accurate the data that you gather and produce is?
Our data is extremely accurate and authentic. We are not, our clients rely on us and have relied on us for a long period of time to have data that's coming from licensed sources, the top data sources that are able to provide that data. And I'm not a developer, so I can't speak to the technical details of the ingestion, but our data and the algorithms that we use to process that data is extremely accurate.
Is your company a member of any associations? Is there anybody that makes sure that you're following whatever kind of rules you have to abide by to make sure that you're providing accurate data?
Absolutely. We are a member of the International Association of Measurement and Evaluation. That's the leading global, it's called AMEC, and that's the global organization that oversees evaluation and measurement. We also are members of CBES, which is the World Media Intelligence Congress. The president of our North American company, Todd Murphy, is an executive on the executive board, and he is a VP of PBES at Congress.
Do you know if you have any kind of margin of error for what you guys produce?
The margin of error for media monitoring is really very low, and that is any margin of error would be as a result of what was published. If something was published inaccurately, we would have that same margin of error.
So you don't get wrong whether or not something was published.
I'm sorry, can you repeat that?
So the fact that something was published and is related to your client's request, you're 100% certain that it's always going to be like a story related to that?
Yes, based on keywords and parameters that we utilize from the client to pull that data.
I see. So we contacted you in this case, is that right?
Yes.
And what is it that we asked you to do?
You asked us to begin to monitor content for all media types about the case.
Yeah, how did we set that up?
So we set up the workspace or the platform, as we call it, and the report. We do that internally with our team of experts. But in order to set up the terms, the messages, and the names for tracking, you provided that to us.
And as a result of that, did you create some, I don't know what we're going to call them, graphs for the court today?
Yes, you did.
And is that what we have labeled as Exhibit A?
Yes.
And is everything in that true and accurate as to what it is that you created using the software that your company runs?
Yes, it is.
Or move to admit Exhibit A?
Any objection?
For purposes of this hearing, no, Your Honor, but I would preserve my objections regarding whether this is appropriate expert information. I'll address some of that on cross.
Okay, thank you. Mr. Radley?
No objection.
Okay, anything to respond to that objection?
I guess I'll wait and hear what the rest of that objection turns into, Judge.
Okay, well, I'll accept that. I'll purposes now, the limited purpose that is also described.
So, Associate, do you have the exhibit on your screen?
I do.
And is it the same exhibit that was attached to the PDF file, the filing that we did in this case?
Yeah.
Can you do a share screen at the first page of that?
Yeah.
So this is the first page that we see after the big exhibit A that I put on the front of it, is that correct?
That's correct.
And what is it that we see in this, I guess we call it a slide?
This is a report that we exported from the TrueScope platform on June 6th, containing data from November 13th, 22 through June 6th, 23. It contains volume, potential impressions, unique authors, metrics over time, key phrases in that particular data set, how people mentioned in that data set, organizations mentioned in that data set, location, and media.
Can you go to the next page?
Yes.
And what do we see here?
This is an aggregate total of volume, potential impressions, and unique authors between the dates of November 13th of 2022 and the 6th of June 2023.
What does total volume mean?
I'm sorry, can you repeat that? I'm a little muffled.
What does total volume mean?
Total volume is an aggregate total of the volume of media coverage for that time period.
So that's every,
That's media for every type that we're tracking.
and then what are potential impressions?
Potential impression is a metric that shows it takes into consideration circulation to show what the readership might be, what the potential total readership might be.
So if that number right there is 2.1 billion, you're telling us that potentially there have been 2.1 billion readings.
Correct.
And I think we can probably guess the unique authors, I take it, is just how many different people have written about this.
Correct.
Can we go on to the next page, please?
Yeah.
What do we see here?
This is metrics over time between the 13th of November and the 6th of June of 2023, November of 2022, to the 6th of June of 2023. And this is a chart looking at volume, potential impressions, and social engagement. Social engagement refers to how widespread social shares are. So engagement, shares, likes, etc.
So based on this, we can see that, I mean, it looks like there's never a time when there aren't publications of some kind coming out about this case.
That's correct.
Why does the potential impressions bump go way up back in January and has completely fallen off even as the volume and social engagement go up?
The potential impression typically is going to rise if there has been some significant event on a particular day or in a particular time period.
Okay, but why is it precipitously dropped even as all these stories are coming out? Are you frozen?
No, I'm thinking. I'm not sure that I have a clear answer for that.
So would that tell us that the stuff that's coming out is the volume of stories increases, that there are fewer people looking at whatever kinds of stories those are?
Objection leading.
I'm sorry, Your Honor, can you repeat that?
Go ahead. Mr. Watson.
You can answer the question. The question was,
Okay,
She wanted you to repeat it.
the question was, would this tell us that even though there's a lot of stories coming out, for example, in May, the actual circulation of those stories is pretty low?
yes, that would be accurate.
Okay. Can we go to the next page? What is this?
This is what we call a word cloud, and it is a chart that we have as part of the TrueScope system that shows what some of the key phrases are in any data set with any particular date range. In this case, November 13th through the 20th, November 13th, 2022 through June 6th, 2023. And what it's showing is what some of the keywords, key phrases that are organically pulled into the data set based on the parameters we set up. The larger wording means that there are more, the volume is higher for the larger the words are.
You go to the next page. This one, is there anything we need to know about this? It seems self-explanatory.
I think it is fairly explanatory. Again, it's top people mentioned in the data set for that same time period, November 13th through June 6th. And again, this is looking at all media types.
Next page.
This is top organizations, same rules apply with within that time period, the parameters that we have set up. These are the top organizations or companies that are listed.
And the next page.
And same thing here, top locations in the data set between the 13th of November of 22 to the 6th of June 2023.
And the next page.
And this is a media type breakdown in the pie chart format between the 13th of November 2022 to the 6th of June 2023. And it's just showing the percentages of content within each media type.
And the next page. All right, well, so this is the one that everybody wants to talk about. Can you give us an understanding of what it is that we're looking at here?
Yeah, this is a chart that our media insights team created based on the content that we exported from the TrueScope platform into a Excel file, PDF, and then charted it on the graph. And it is showing the content for each authority figure and what we call share of voice. So that's volume and impressions, and that's showing the time period of 11/13 of 22 through 4 of 23.
Can you explain the share of voice a little bit better?
Sure.
How do you know? I mean, it makes it sound like, if, for example, we're talking about the Moscow police, they get to talk, I guess, what the most? I mean, what does that tell us?
Sure. So what this is showing, the Moscow police, let me pull up a little bit more. So the Moscow police have the highest volume in the data set, and then we put that number in that data set. and the volume is in blue, and the potential reach is in the dark. It's purple, but it looks more blue here. So the Moscow police have the highest volume in the data set. That meant that they were featured or quoted or somehow listed in 24,585 stories. With that, they have the largest potential reach, which is central impression. And you see over to the right that we have potential reach listed on the right hand column side. And so that is at almost 62 million impressions. So that means that and I'm not, I don't know that you want me to interpret the data, but this is an aggregate look at how far the potential of the messaging from each of these names and or organizations went through the data set.
And to the extent that you have listed David Nye instead of Jeff Nye, is that our bet?
We did not change any of the names that you provided.
Okay, next page, please. So this is essentially the same thing, is that right?
Correct. That's correct.
And in terms of the concept of what's authority versus non-authority, where did that come from?
Authority versus non-authority came from your office.
I guess what she said came from,
Me, Judge.
oh, you, okay, thank you.
Yes.
Next page, Judge. Sorry, associate. And this is just another slide comparing Mr. Gray.
This was.
Yeah.
Correct. So this slide, your office asked us to prepare for these particular names to do a share of voice chart showing what each of them, where each of them fell in the data set and on the chart.
Is that the last page? Are we done yet?
Then we have a chart sometime.
All right, well, I don't believe I have any other questions for you, but you may get some from some of the other attorneys. Thank you.
Thank you.
Thank you, Mr. Logston.
Remember, I have a hard copy of Exhibit A. Does the court want that to place in the record?
Yes, please. I'll be admitted. Defendants A. Mr. Rudley, do you want to weigh in at all?
We have no questions, Your Honor.
Okay, Ms. Olson.
Thank you, Your Honor. Good afternoon, Ms. Saucier. My name is Wendy Olson. I represent the Intervenor Media.
Good afternoon.
Ms. Saucier, where are you coming to us from?
Do you mean my location?
Yes.
I'm in Chicago, Illinois.
And when did the Kootenai County Public Defender's Office hire you for the work that you've done in this case?
The first day of our agreement was February 15th, 2023.
So February the 15th of 2023?
That's correct.
And in all the data that you've shown here in court and are in Exhibit A, I know that starts at November 13th of 2022 and goes to June 4th of 2023. Why did you start with November the 13th of 2022?
Because that is the date that our client asked us to begin searching, and we were able to pull in historical content previous to the agreement or the data we started searching for most media types.
And I apologize, associated with the copy of your report that I have, it's Exhibit A, doesn't have any page numbers that are in it. But if you could look at, I mean, let's just pick the one that is, metrics, well, let's start with the first one, I guess it's page 2 of exhibit A. If you wouldn't mind putting that back up, ma'am, so we can see it here in court.
Sure.
They're right there.
So page 2.
No, sorry, the one above that, the first thing is total volume, 46K. All right, and this one, is there any way that we can tell from this slide how much of that volume occurred from November the 13th of 2022 to December 30th of 2022?
Not from this slide, no.
And is there any way we can tell from this slide how much of that total volume occurred after January the 13th of 2023?
Not from this slide, no.
And then would that be the case for all of those slides? If I'm looking at anything in exhibit A, the only thing it tells us is what happened over that large period of time, and it's not broken down by date set, correct?
From this slide, it is not broken down
Yeah, and so if we go to the one
into
that
the narrow date, but
I apologize. And for the one that says authority figures share of voice, and again, I don't have the pages, so I apologize. And that one there that says, Moscow police and is just under 25,000. You can't tell us how many of those were before December 30th of 2022, how many were after that, how many were before January the 13th, and how many were after that. Is that correct?
not from this slide, that's correct.
And Ms. Associate, when Mr. Logston asked you the question about David Nye, I assume you don't know who David Nye is, correct?
If you mean personally, no, I do not.
Well, at all, do you know who he is have you learned who he is in the course of all of this?
I did not spend a lot of time looking up or researching any of the authority figures or the non-authority figures.
You just took the information that Mr. Logston provided to you, is that right?
That's correct.
And so you have no idea of knowing whether in fact the person is an appropriate person to include in the data set as an authority figure, or if they're not, is that fair to say?
We utilized the name that we were given from our client based on their knowledge and expertise.
And you have, as some of the information that you prepared as an addendum anywhere where we can look in order to evaluate your information at that list of names that were provided to you by Mr. Logston?
I'm not sure that I would have the authority to provide that to you.
Okay, well, that's data that you used in your analysis, right?
That's correct.
And with respect to this data set, what do you mean by that, the data set? What is that?
The data set is the volume of coverage that is in our system based on the dates that we have filtered for. So in this case, for these slides, we filtered 11, 13, 22 through the date that we created these, each particular chart. In this case, June 4th, 23, to get the most accurate data set, most up-to-date data set.
All right, but what's in that data set? Is it a whole bunch of, is it 20 different media sources that you run search terms against, and then somewhere downloaded is all of the stories or whatever you want to call them that come back when you run that set?
So in the platform for the workspace that we have set up for our clients, all of the content that we have ingested since we started working with that client, and this is the case for any client, any coverage that has come in through our system that has been tagged, for lack of a better word, to just try to explain it, that has been pulled into our system is in a platform, a workspace, a web-based workspace, and we have access to pull all of that data or to filter based on a name or organization or any number of many other filtering options.
Okay, so I guess again, just not understanding how you get the data set. So is it like, let's say, on November the 13th of 2022, somebody ran a story about a 911 call made to the Moscow Police Department, and it runs in, it's an Associated Press story, so it runs somewhere initially, and then it gets picked up by a bunch of other people. How does that get captured in this data set that you're talking about?
So from how that gets captured into this data set is through the front end of our system. That data resides and is housed and stored. And so let's say it was an AP story that is in, that has fulfilled the parameters that we're searching for. That story will be in the workspace, in the platform, and we're able to pull that based on filtering parameters. Let me try to explain it a little bit more clearly.
And are you looking at something then?
Pardon me?
Are you looking at something as you're trying to provide an additional explanation of what this is?
No, I'm not.
Okay.
But we use the front end of our platform, which houses the data that's pulled in from the back end of the platform, and that data is pulled in from our data sources, ingested in a number of different ways, primarily API feeds.
And so is the data like a news story about, that they've given you one of the terms?
Yes.
Okay.
Yeah, so it's the published content. I'm sorry, maybe I wasn't clear about it. It's published content.
So the actual story would be there, is that right?
That's correct. That's correct.
And for whatever the actual story is in there, to put these charts together, you went through and just basically counted in how many of those stories certain terms appeared, is that right?
That's correct.
Okay, so there's no effort to like qualitatively examine what the story has, right? It's simply a counting exercise about how many times certain terms appear in the various media sources that get ingested into your platform, is that right?
Yes, in this case, and in many of the cases for our clients, we are looking at quantitative total versus qualitative.
And a lot of times, it's because you want to see what sort of phrases your clients want to see, what sort of phrases are catching on with the media, right?
There could be any number of reasons for doing that.
Including that, right? You know, if you have a new like slogan, someone might hire you to see, hey, is our slogan being picked up on Twitter or those sorts of things? Is that right?
That's right.
Okay, and that's sort of where that idea comes around for that word. I forget what you called that, the word thing where some of the words were bigger than others.
Correct.
Yeah. And so, Ms. I have a few more questions for you, Ms. Saucier, although probably everyone else in the courtroom should want this one, sure. So with respect to these charts we're on now, this authority figures share of voices. The next one is a non-authority figure share of voice, correct?
Correct.
And you said that that's a term that came from the Kootenai County Public Defender's Office, right?
That's correct.
And so that's not a term that you ordinarily use in the work that you do through TrueScope?
That's correct.
And it says that, and I read your definition, and it must be the one that was provided to you it's not on that page, but it's two further. And it says non-authority figures are experts who currently work in or formerly worked in the field of law enforcement, police or FBI law, such as lawyers or other court-related personnel, but who are not working on this case, correct?
That's my understanding.
Yeah, well, that's information that was provided to you, right?
Correct.
And so you didn't like use really any expertise there. You just used the definition they gave you and counted some stories that had these names in them. Is that right?
I'm not quite sure how to answer that question.
Okay. Well, let's back up to the one that says non-authority figures share of voice. Now, the one above that. Right there, yeah, right there. And the person that has the highest number there, and I guess there's this other line that talks about potential impressions, I'll come to that in a minute. But this line that says Rebecca Boone, AP reporter, I take it that's information that was provided to you by the Kootenai County Public Defender's Office as well, is that right?
That's correct.
Yeah, do you know, I mean,
However,
do you know?
however-
Go ahead, Mayor.
as we're looking at media content, our platform pulls in the content and also takes us to that original published story. So we are able to see if something is written by a reporter, such as what's the case here for Rebecca Boone.
Okay, but my point, so she's an AP reporter, but she's not, as far as you know, someone who currently works in or formerly worked in the field of law enforcement, correct?
I do not know anything about her background.
Well, would you agree with me that if she's never currently or formerly worked in the field of law enforcement, law, and those things previously, but is not working on this case, she would not fit the definition of non-authority figures that you used in your analysis?
That's correct.
And did you do any sort of quality control on this, Ms. Saucier, to determine whether, in fact, the individuals listed here were persons who currently work in or formerly worked in the field of law enforcement?
I did not do background research on the names that we were given from our client, nor did I do background research on names that appeared organically in the data set, which many of these on this chart did.
And so you didn't check whether or not any of these people actually were currently or formerly working in law enforcement, right?
I did not do a deep dive into anyone's background.
Including Ms. Boone's.
That's correct.
And Ms. Saucier, would it be fair to say that, there's a number of journalists here in the courtroom today, and that if they all write a story about this and talk about your presentation and indicate that you have things in your chart that refer to Ms. Boone, and that I ask you questions about Ms. Boone, into your data set are going to pop all of those other stories, or stories that refer to Rebecca Boone. Is that right?
Can you repeat that question?
Sure, it was kind of long, it's a bad question. So, Ms. Saucier, there are a number of journalists here in the courtroom this afternoon, and if they all write stories about this hearing and mention that there were slides in your presentation that referred to Rebecca Boone, and you were asked questions about Rebecca Boone, those stories they write that refer to Rebecca Boone would then pop up in your data collection that your firm is doing for the Kootenai County Public Defender's Office, correct?
Stories may pop up, but based on volume, they wouldn't necessarily have a very large share of voice if we were to be charting for looking at them from that path.
My question was just whether they would pop up in your data set.
They would pop up in the data set if it was about the same, yes.
And you're familiar with the Associated Press, I take it, Ms. Saucier?
Yes,
And you know how they work. A reporter for the Associated Press may write a story in Moscow, Idaho, and once they put it up on the wire, that could get picked up in all sorts of exciting places like Des Moines, Iowa, where I went to college, or let's say Crete, Nebraska, right outside of Lincoln, or any of those places, right?
that's
And they might run, because they run in a different publication, they're going to be counted as a different story. Is that right? In your data set.
correct.
Ms. Saucier, I have a question about, I think it's on 2 pages later. It's the second page of your exhibit B. Is that in evidence?
Yes.
All right.
We
Well,
can
then,
put it in.
Yeah, well, it's submitted to the court. So I don't mind offering exhibit B. Do you have that with you, Ms. Saskia?
I would move to admit B.
Okay, no objection?
No
No,
objection.
I thought I was offering it, but that's all right.
You are, well,
Okay.
okay,
Anybody who wants to offer can.
all right. It's a dual offer. I'll accept that, no objection.
We all want exhibit B. And so I apologize, Ms. Saucier, and I know it's late in the day, but your document was upside down. So is there any way you can turn that so?
Yep.
All right, so we can go down to, on the second page of the text of exhibit B, it says impressions. And do you recall discussing that term when Mr. Lawson was asking you questions?
Yes,
And so you say here that circulation impressions should be considered as opportunities to see a story, correct?
that's correct.
And not the actual number of individuals who read or viewed the story, correct?
Yes.
And so there's no guarantee whatsoever on any of the potential impressions that anybody read the story, correct?
That's correct.
And there's nothing that any of this that tells us that what was in the story, correct? Other than maybe these terms.
Can you repeat that question?
Sure. And there's nothing in any of what you've provided to the court that tells you what is in a story other than the terms that you were asked to search for. Is that right?
I'm sorry, I'm still a little unclear on what you're asking.
Sure. And the data set that you gathered, well, strike that. In the exhibits that you put together, exhibit A that you testified about, and then exhibit B that's on the screen now, there's nothing in that that tells us what the substance of the story is, other than it had certain terms in it, correct?
That's correct.
Ms. Saucier, have you ever testified in court as an expert before?
I personally have not, but others in my company have.
And with respect to this particular exhibit and thing, what work did you do on this project?
I filtered and collected the data that we utilized in shared voice chart, and I also produced, filtered, collected, and produced the first part of the chart that was produced on the platform. So,
Yeah. And then what, if any, sort of quality control was there done to determine whether or not you pulled the data accurately?
just trying to figure out how to answer that. So I'm trained on the platform. I know how to filter through the data, and I filtered through that data accurately. The data, the parameters that were in the keywords and search terms are set up accurately. So that gives us accurate results.
And have you ever used Westlaw, Ms. Saucier?
Not personally, but I'm familiar with, I know what it is.
So is the process you're describing sort of similar to running a search in Westlaw, and then you get a certain number of hits, and you know that that search term actually produced those number of hits because that's just the way the software works?
Similar. There's a little more to it than that, but that's a decent summary of how our systems, our software may work.
I have just one moment, Your Honor.
Yes.
All right, thank you very much, Ms. Saucier. Hope all is well in Chicago.
Thank you.
Thank you, Ms. Olson. And you're not seeking any questions, Mr.
Mayor,
Mr. Belli is saying no. Anything to follow up? Because then we're going to take a break. You want to follow up on any questions there?
We're good, Jeff.
Okay, excellent. Thank you, Ms. Saucier. You can be
Hello.
excused. Hello?
Hello?
Hello? I'm getting an echo somewhere.
Oh.
Okay, from you, Ms. Saucier, you're excused. You can stay on if you want, but you probably have other things to do. So thank you for being here today. We appreciate your answers. So.
Yikes. Jesus. Okay. Well, I think it's time for bed. I don't know that I can handle another one. But I appreciate you all for being here. That got a little hairy. There's like many things that I need to go look up now, and I'm exhausted. Where did they get that lady? You know what? We'll talk about it. We'll talk about it tomorrow. I can't, but hopefully you guys liked the letter in the beginning, the reading of the letter, but Jesus, this was the end there. I'm seeing like a lot of the same reactions that was like me the whole time. She drifted off. Okay. Well, I love you guys and I appreciate you being here. But there was a lot of good stuff. It just got real scary there at the end. I think when I saw BK's like forehead wrinkles start bunching up, he was like, "Really? Like you're not going to answer that? You can't answer that?" Every pause like made me so nervous. But good night and I hope you come back. Maybe we'll play the other part tomorrow. All right, bye everybody.